My name is Jeff Morgan, and I'm going to be talking about the oath or affirmation to testify truthfully. Now, if you go to the Texas Rules of Evidence, and this is effective January the 1st, 2018, Rule 603 that says the oath or affirmation to testify truthfully. Before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. And this Rule 603 actually comes from federal rules as well. Rule 603 federally says this: the oath or affirmation to testify truthfully. Before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. And so now that we've looked basically at what Rule 603 says, it talks about the oath or affirmation to testify truthfully. I wanted to look at this a little bit more in depth because there was an article that I found in Michigan Law Review, Volume 75, Issue 8, and this goes back to 1977. It was the reconsideration of sworn testimony requirements, securing truth in the 20th century. Now, I thought this article was very interesting because it talks about upon observing the swearing in of a witness, one might justifiably conclude that the procedure is just a ritual without much substance. Do you swear to tell the truth, the whole truth, nothing but the truth, so help God? I do. The way that it's done today, it appears that, well, it's just a ritual. We say this and we just rush through it. But it actually is not designed to be just a ritual in itself. The superficial nature of the ritual, however, belies the deep reverence in which the law purportedly holds the oath. A man of most exalted virtue, though judges and jurors might place the utmost confidence in his declarations, cannot be heard in a court of justice without an oath. This is a universal rule of the common law, sanctioned by the wisdom of the ages, and obligatory upon every court of justice whose proceedings are according to the course of common law. Grounded in the belief that the oath represents the highest possible security which men in general can give for the truth of their statements, the sworn testimony rule remains a maxim fundamentally unchanged since the early common law. Now, this article goes into a lot of the history of it. I'm just going to touch about a few things right here. Before testifying, every witness shall be required to declare that he will testify truthfully by oath or affirmation administered in a form calculated to awaken his conscience and impress his mind with his duty to do so. When you look at some of the history of this, at one point in time, only Christians were allowed to actually testify in court. And I believe some Jews were allowed at the same time. But if you were an infidel, if you were a person that did not believe in God, your testimony was not even permitted. The idea was that a Christian would be truthful because if the Christian were to lie to God, that God would strike him down or judge him in the afterlife. And this article again goes into a little bit of some of the history of it. Unsworn oral testimony has been admitted as evidence in open court only under the most exceptional circumstances. The invocation of a general waiver doctrine and the situation typified by Wilcoxon clearly conflicts with the court's interest in ensuring the truthfulness of testimony through the oath requirement. So the oath that we give when we go to court is not just a ritual. This is supposed to be a real big deal. Again, too often we look at it as, okay, just rush through it real fast. You swear to tell the truth, the whole truth, nothing but the truth, something God. Yes, I do. And that's it. But really, it is designed to impress upon the person who's giving testimony the necessity of speaking truth. So the requirement that witnesses be sworn has its foundation in the unusually unexpressed assumption that all testimony is inherently corrupt due to self-interest or indifference of the witness. So if you're up there giving witness, you are going to try to shade things so that you look better or that your interests are promoted. The law has never relied upon the native honesty and search for truth. Rather, from the very beginning, it has sought through the oath to gain security against the vicissitudes of human nature. And going down further, to obtain this guarantee, the law expected that in taking the oath, the witnesses would form an ironclad covenant with his God, pledging his eternal soul as security for his promise to testify truthfully. If I did not testify truthfully in the court of law, God could take my immortal soul. He could plunge me into hell. This was how serious at one point in time, we took the oaths. And again, people that did not have the requisite religious belief could not be sworn, and thus they could not testify. The purpose of the oath is not to call attention of God to the witness, but the attention of the witness to God. Not to call upon God to punish the false swearer, but on the witness to remember that God will assuredly do so. By thus laying hold of the conscience of the witness and appealing to his sense of accountability, the law best ensures the utterance of the truth. In Perry versus Commonwealth in 1846, the court stated that all who believe in God believe that through the oath they incur a higher obligation than by a simple promise or asseveration. Under early English law, only Christians and, by most accounts, Jews were deemed to possess the belief necessary to be sworn in as witnesses. It was not until 1744 that the class of acceptable religious followings for the purpose of the oath was expanded. Again, this article goes on into a lot of these things. I'm not here to discuss the entire article, but it is a reconsideration of the sworn testimony requirement, securing truth in the 20th century, Michigan Law Review 1977. And the reason I'm bringing this up is because when I went to Mineral Wells in October, and I saw when I witnessed the part of the trial between Brandon Johnson and his ex-wife Regan Johnson, and this took place before Judge Michael Moore of the 29th District Court in Palo Pinto. I thought this was very interesting because at one point in time, Brandon and the judge had a big discussion about the issue of the oath. Brandon is starting to testify. Brandon, by the way, is Mr. Johnson, and the court is the judge, of course, Judge Michael Moore. So we have Brandon Johnson and Judge Moore, Michael Moore. Brandon means Mr. Johnson, Michael Moore or Judge Moore means the court. So the judge is saying this. We've already gone over the witness issue, but I'm going to allow you, and this is the way I do it, okay? I try to be fair, and I'm going to let you tell me what you want to say after I swear you in as a witness, okay? You can say whatever you want to. She is entitled to object to what you say based upon legal principles, and I'll rule on those objections if and when they come. But this is your opportunity to talk. So Brandon is talking about various things. He said that don't understand the legal society and that taking place today. But again, Judge Michael Moore says, well, if you start talking to me after I put you under oath, she's going to get to ask you a question as well. That's not a very complicated concept to understand. You do understand that, don't you? And again, Mr. Johnson said, well, I don't understand this legal society and how you all work. And they have a little bit more going back and forth. But before you do that, I need to put you under oath. This is what Judge Moore says to Brandon Johnson. Can you raise your right hand? So Mr. Johnson says, well, sir, with all due respect, it's against my religion to swear an oath of allegiance. And actually in that law article that I just talked about, the reconsideration, they actually talked about these issues. When if you had a religious person, like say a Quaker, the Quakers may not take an oath. What do you do in those instances? So Brandon is just saying, hey, it's against my religion to swear an oath of allegiance. The court says, I'm going to say swear or affirm. And again, going back to this article here, they talked about how they made allowances for non-religious people to start swearing. And so, they couldn't have every atheist, if an atheist believed that by telling a lie he might be put in jail, that was considered enough. There was some punishment that was there. There was supposed to be somehow binding his conscience to making him tell the truth. So you can swear or you can affirm, and that's what they say today. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Or something very similar to that. You don't have to. When I say the oath, I say swear or affirm. You can either swear that you're going to tell the truth, or you can affirm to me that you're not, that you're going to tell the truth. Swear, or I'll just say, and I don't know what this thing about the yellow jacket is here. So going back down to the bottom here again, Judge Moore says this. All right, going back to what I was saying, you don't have to swear to God that you're going to tell the truth. You can affirm to me that you're going to tell the truth. So, but I'm not going to let you talk unless you affirm to me. You must affirm to me that you're going to tell the truth under penalty of perjury. So can you raise your right hand? And once again, Mr. Johnson says, well, sir, I don't understand completely. Can you tell me? I'm trying to figure it out here. I'm not trying to be the court. Yeah, I'm not trying to cause a disruption. I understand. With all due respect, who am I swearing allegiance to? Or you're not swearing allegiance to me or to anybody, to God or to anybody. Okay. You're affirming only to me that you are going to tell the truth here under penalty of perjury. That's all you're affirming. That's all you're going to tell. Mr. Johnson says, well, I will say, I would testify to what is true, what I know to be true, but I don't know what the truth is. Now, Judge Moore goes on further, well, how am I going to know if you don't know what the truth is? How am I going to know you? How are you going to be able to affirm what you're saying is truthful if you don't even know what the truth is? Mr. Johnson responds, well, what I am saying is, if I know it to be true, I'll verify it as true. Okay, so you're telling me you're going to be truthful with me. Mr. Johnson says, I will affirm what I know to be true, yes. And Judge Moore once again, but are everything you tell me, is it going to be truthful? Is that correct? Mr. Johnson, it will be truthful to the best of my knowledge, yes. The court, okay, do you understand if it's proven that you intentionally lied about something, that's subject to perjury statutes, and that's a felony offense. Do you understand that? Mr. Johnson says, I understand that I, as a man, do not lie to my fellow man. So the court says, okay, well, all right. Well, regardless, I'm here to tell you that if you lie intentionally under oath in court, that is a felony offense. I'm not saying you're going to do this. I mean, we're fighting over something we shouldn't have to fight about. I mean, you know, at the bottom of your heart that I require the truth in this courtroom. I'm called upon to make decisions concerning children every day, almost every day. Also, in criminal cases, people's liberties are involved. They can go to prison. And I expect everybody to come into this courtroom and tell me the truth. Because justice demands that. That's all I'm asking you to do is tell me the truth. Of course, Mr. Johnson, I will tell you what I know to be true. And like I said, what I don't understand is, I want to show respect here, okay? I do. I'm not trying to cause controversy. Sure, the reason I'm here today, sir, is to remove this controversy. And that basically continues on from there. And basically, he's allowed to testify. He's kind of given the affirmation that he would tell the truth. Now, this was a big deal to me because as I read this, at the beginning, I listened to, because I was actually in the court at this time, and I listened to this, and I thought, oh, good night. This is going on and on. And I don't know if this was intentional by Mr. Johnson or not, but I thought it was a very interesting conversation. This is on, again, pages 67 through 72 of the transcript. But I want to go up to page 17 of the transcript. So on page 17, this is Miss Bryan, and Miss Bryan is Regan Johnson. Regan Johnson, by the way, is the mayor of Mineral Wells. It's Brandon's ex-wife, and she's been the one who's been keeping the kids away from Brandon. And she's trying to have all sorts of, some type of motion against Brandon. I don't remember what all the details were, but that's not really important for this purpose right now. So anyway, Miss Bryan invokes the rule. Having said that, I want to make sure that everybody understands that even if they're outside the courtroom right now, they will not be allowed to testify, because if somebody had, with the rule, at this point in time, if there was other witnesses that were identified other than the two parties, because only Mr. Johnson and Regan Johnson, who, again, the mayor of Mineral Wells, I would bring them into the courtroom right now, whether they're inside or already in here, and I would swear them in as witnesses. So what he's saying right here is that if there's any other witness other than Regan Johnson and Brandon Johnson, I would have to bring them in. I would swear them in as witnesses right now. And I would make the instructions, the proper instructions under the rule of exclusions of witnesses, which means primarily they are not to talk about this case while they're outside with anybody other than you or Miss Bryan, the attorneys, okay? So y'all have not identified anybody as potential witnesses, so there's not anybody out there that's going to be subject to the rule or in here either. And so nobody is going to be told to talk about the case. So with that, I want to make it absolutely clear to everyone that there's not going to be any witnesses other than the two parties. So having said that, is there anybody, Mr. Johnson, that you want to identify as a witness other than yourself? And Mr. Johnson says no. So after Mr. Johnson says that he has nobody identified as a witness other than himself, the court says, all right, All right, you may proceed. And as we go down to Miss Bryan, again, the attorney for Regan Johnson, the court and the witnesses will go over here. The parties will go over here to the jury box. You may proceed. Now, the question that I have is this: was Regan sworn in as a witness? So it was very interesting how Judge Moore took all of this time with Brandon Johnson. Again, I don't know if Brandon did this intentionally or not, but I mean, there's 5 to 6 pages of the transcript talking about being sworn in, the necessity of being sworn in. And again, looking back at that article that I talked about, a reconsideration of the sworn testimony requirement, it is a requirement. The Texas Rules of Evidence, Rule 603, and again, this is a federal rule as well. Before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. Now, my question is this: if Regan Johnson was never sworn in, could she be convicted of perjury? She made no affirmation that everything that she said was true. So why does she have to? She could lie about the whole thing. But I have another question as well. Should any of her testimony be allowed, period? She has made no affirmation that what she was saying was going to be truthful. From my understanding of the way things work, she really cannot be convicted of perjury, but at the same time, all of her testimony should not be considered. Judge Michael Moore made a huge mistake. Judge Michael Moore never swore her in. And without her being sworn in, again, according to the Texas Rules of Evidence, before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. So what happened? Did Judge Moore just forget to swear her in? He most certainly did not forget to swear in Mr. Johnson. He spent 5 to 6 pages in the transcript. He did not forget that he had an obligation to swear other witnesses in. Why did he give Regan Johnson a pass? I don't know what the answer to this is. I really don't. And I have nothing against Judge Moore, but this seems to me to be an egregious error. This seems to me to be something that Judge Moore did that calls into question the entire trial. And personally, I wonder if this should not be appealed, because if Regan Johnson is not under oath, I don't know that she can commit perjury, and I don't know if any of her testimony should even be permitted or considered, and especially used against Mr. Johnson, because she has her own self-interest in mind. There was no impression made upon her conscience that she must tell the truth. And again, according to the Texas Rules of Evidence, before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. So from what I can see, and I'm not an attorney, and I always have to say that, right? I'm not an attorney. Attorneys never have to tell us they're not theologians. They don't have to tell us they're not psychologists. They don't have to tell us they're not doctors. They're not sociologists. They never have to tell us that. But we always have to make the disclaimer that we're not attorneys, that what we are giving is not legal advice. But from what I've seen, it would appear to me that none of this should be used. I believe that Judge Moore, at the same time, has not upheld the proper decorum that is supposed to take place in a court. We had people that came up there. There were about 20 people that came up to this thing. Some drove from over 250 miles away, spent 5 hours or more on the road coming up here. He excluded us from the courtroom, which is against the Texas Constitution. It goes against the open courts doctrine. We must keep the courts open. It is the public's right to go into the courts. There was no reason that Judge Moore should have kept us out of the court. That was a capricious decision that he made. He kept people out of the court. We as the public had the right to be there. He kept us out. The whole thing should have been thrown out. And now, by not swearing in Regan Johnson, I believe this entire case should go to appeals court. I'm not advising Mr. Johnson, but it's just a consideration for him. And perhaps because of this stuff, as we see that he went into great detail with Mr. Johnson, it almost seemed like he was acting perhaps in a little bit of a discriminatory way toward him. He was going to make sure that Mr. Johnson had this duty impressed upon him. Maybe he thought Mr. Johnson was lying, but maybe he had the thought that Miss Johnson, Regan Johnson, would tell the truth. And that, to me, seems to impugn his impartiality and objectivity of a judge. That Judge Moore should be recused from ever hearing another case between Mr. Johnson and Regan Johnson. And perhaps the State Commission on Judicial Conduct actually needs to give him a public warning to remind him about his duty to swear in witnesses prior to them giving testimony. Thank you.